Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. And now your hosts, Tim Kowal and Jeff Lewis.
One of the differences between the California state appellate system and the federal system is that in the California state system, we don't have horizontal stare decisis, meaning that a court of appeal in California can look at another district court of appeal opinion as persuasive or not. If the court is not inclined to agree with that holding, it can treat it as if it doesn't exist. And I wondered if you thought from your time on the bench that this makes a big difference or a small difference in your work as a justice deciding the cases. Is this something that practitioners ought to keep in mind?
Well, there's a parallel question there, and that is the perennial fight over whether or not you can cite unpublished cases, which are available to everybody. And it's an ill-kept secret that a court of appeal justice can look at an unpublished case and like the reasoning of it and find a way to put it in an opinion. You make me think of a recent arbitration that I did, where I actually put a footnote in pointing out that if you read the Monchar's decision from the Supreme Court that Justice Lucas wrote, if you read that carefully, it essentially says that an arbitrator can look at anything. You're not going to have an appeal on it. You're not limited to published opinions. So I think I might have shocked the parties, because I had this arbitration where both sides were arguing at great length unpublished opinions and complaining that the other guy shouldn't be allowed to cite them. And of course, I found all of them very persuasive, and wrote an opinion that way. So you can always find a way to get the reasoning into the case. And as I would admit that a court of appeal justice will do that and adopt the reasoning of the case. So I think that happens in all the court systems. It's not, once again, it's not a big community, so we know what other people have said.
Yeah, no, that's a good thought. I mean, the point that a lawyer may not cite an unpublished decision, but that practitioner could still copy and paste the language, that reasoning, make the same argument, and it has as much binding authority. The reasoning has as much binding authority as another published district court of appeal opinion, in that it doesn't have any binding authority. It's what the court of appeal decides it finds persuasive or not.
Well, and I can't give you any citations. One thing I loved about my friend Justice Klein is that he could give you the citation for every case he ever wrote, which is interesting. But if I had some time to study it, I could show you some appellate opinions that contain the reasoning of unpublished opinions, which then makes them published, which is the way it works. So the right answer is where you find it.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.